Good afternoon and welcome back. I'm Mark Speeder, talking with my friend Andrea Picciotti-Bayer, legal analyst for EWTN News, director of the Conscience Project. Follow her work at conscience-project.org. Andrea, great to speak with you. How are you?
I'm doing great, Marcus. How are you?
I'm very well, thank you. Great to speak with you as always. We've been following this case about First Choice versus Davenport. For the sake of our listeners, let's recap what's been going on here.
You know, this is a very interesting case, Marcus, and I'm really glad that we have a chance to talk about it because it kind of touches upon the I guess, relentless activity of the abortion industry just to kind of shut down pro-life voices. And fortunately, we're hearing from the Supreme Court time and time again that women can have alternatives to abortion, and that efforts by government actors to silence them, to muzzle these other choices, is against the protections that we find in the First Amendment. So just to kind of give a brief overview of the case, the Supreme Court basically said that in a unanimous decision, which is really showing how this issue spans the different political inclinations of the justices and really goes to the heart of the Constitution, said that the New Jersey's Attorney General really violated the First Amendment rights of First Choice Women's Resource Center, which is a faith-based pro-life pregnancy center in New Jersey, by issuing administrative subpoenas, demands for records that included the records and the identities of their donors, and said that such a kind of misuse of law enforcement authority, especially when there was no complaints levied against this resource center, was aimed and directed and actually caused injury to the First Amendment by chilling the associational rights of people that wanted to support the center itself. So it's really kind of amazing, first, that the First Amendment would be so protected across the board. The 9 justices saw this subpoena issue for what it was, and that we are still in a place where the abortion industry has allies in different state governments and is really trying to shut down options for women that aren't directing them to abortion clinics or to pharmacies where they're going to get abortion pills.
Matthew Platkin was one of the names involved in this. What do we think was one of the motivating factors for the Third Circuit's decision on the case?
You know, it's really hard to understand. Matthew Platkin was the former Attorney General in New Jersey, and after the Supreme Court's Dobbs decision, where they struck down Roe versus Wade, saying that the Constitution didn't create a right to an abortion, several pro-abortion governors and attorneys general put together kind of within their own states a plan to enshrine abortion in their states, and New Jersey was one of those. And so Attorney General Platkin put together what he called a reproductive rights strike force. Mm-hmm. In 2022, which was really about protecting the abortion industry's monopoly around the narrative around pregnancy, and targeting, like I mentioned before, First Choice Women's Resource Center, which has been operating in the state since 1985, offering counseling, material support, genuine care for pregnant women who don't have those natural supports that they should have in their lives. And it was really kind of absurd, the assault against this ministry, and really burdening them with administrative subpoenas, asking for the production of documents where there wasn't even any kind of indication that there was fraud to donors or any kind of misleading activity. And really, it's kind of like death by 1,000 subpoenas, mm-hmm. Instead of paper cuts, trying to burden the pregnancy center, which is staffed very leanly by paid employees and often predominantly volunteers, to get most of the resources to the people who need them, which are the women and their children. this is, Platkin, fortunately, is no longer in his position. That's why the case is named Davenport, which is the New Jersey Attorney General. I'm hoping that she changes her tune.
The reproductive rights strike force, could that be construed as some kind of a constitutional overreach in the way it executed its mandate?
Well, heck yeah, right? I mean, it really was. When you dedicate people who are part of a state's top law enforcement officers, right? Because that's the Attorney General. The position of the Attorney General is the state's top law enforcement officer. And you say to them, we want you to focus your efforts on basically muzzling or trying to shut, put out of business pro-life centers using these tactics that we have. You're basically violating the First Amendment, and that's what the Supreme Court said. Is they said that this center should be able to make their claim in federal court. That was another interesting thing that the state was trying to do, is they were trying to say, hey, now you can't go to federal court claiming overreach. You have to stay within the state courts. We're not really doing anything here until a subpoena is enforced. And just the issuance of a subpoena, the Supreme Court said, caused an injury to the First Amendment rights, the associational rights, the speech rights of donors. And this is what's really beautiful and interesting, is that people who normally on opposite ends of the aisle, opposite sides of the aisle in litigation, the ACLU, different typically progressive groups came in defense of First Choice because they know they too have donors who want to support their work. And if their donors are fearful that their identities would be revealed, that they would be the subject and a target of kind of a shakedown from law enforcement, that's going to interfere with the ability of these organizations to advocate for their mission. And so they were supporting First Choice, and that is a good reminder that the guarantees of the First Amendment are not partisan guarantees. They're American guarantees, right? They're non-political guarantees, the right to speech, to association, to press, to free exercise of religion. It's not only for people with a conservative or a liberal bent, but these are American values that the Constitution safeguards. And in this case, 9 justices, all justices in the Supreme Court, said need to be able to be protected in our federal courts.
One of the things that you've highlighted in the past, too, is that the First Amendment protects your right to associate with, in this case, different institutions, organizations, and bodies as it pertains to one's beliefs. And therefore, the subpoenas that came out of Platkin's strike force would have put sensitive donor information at risk. And so individuals who donated would themselves be subject to some kind of risk. Can you please comment on that?
Well, and we can see it from the top down, right? I mean, just think about the Supreme Court justices. We've spoken about this before. Marcus said that many of them have been targeted. Their homes have been picketed. Justice Brett Kavanaugh, actually, someone, had a plan to kill him because of his decision and voting in support of kind of a true understanding of what the Constitution protects and what it doesn't protect. And so if we can see publicly that these public figures are being targeted for their decision-making, individual Americans that are supporting life on the ground level are certainly going to be concerned that their identities could be published and that their anonymity would be not respected. And this is something that we know as Catholics we need to be able to support and protect charitable giving across the board.
Andrea, as usual, thank you so much for bringing to our attention these very important cases. My guest has been Andrea Picciotti-Bayer. She is legal analyst for EWTN News, director of the Conscience Project, and she has been talking with us about a notorious American lobby losing a case, in this case, Women's Resource Centers versus Davenport.